So as a dispute resolution professional, the other critical part where the clients come to you after you draft out an arbitration agreement, the parties are engaged in their business activities, is when a dispute arises. So what you should be thinking or advising your client as a dispute resolution attorney or a practitioner. What are those important factors is what we'll be talking about right now. So the first important factor is to have a meeting with the client, understand what the nature of dispute is, to see if that particular dispute fits into your arbitration clause, it's arbitrable, then proceed on the nature of claim that your client may have, the merits of that claim, the nature of documentation involved, prepare a thorough requisition list for your client, ask him for particular documents to substantiate the claim. So these are the steps you take before you even commence drafting an arbitration notice to ensure that the arbitration notice is not rendered faulty. It does not hinder the process of arbitration. So sit down with your clients, understand the factual matrix of the matter, understand the nature of documentation, review each document thoroughly to understand the merits, and then go on to advise your clients. Now, an important factor in advising your client, even at the stage of notice, is that if subject to its applicability, if your clients are intending on filing a Section 9 application for interim relief, you have to guide them as to what are the factors that need to be included in your interim relief application, because as you all know, and we'll learn ahead also, that a Section 9 application can be filed either before initiation of your arbitration proceedings, whilst the arbitration proceedings are on, and after, but before award is passed. So this is from the perspective of a claimant's attorney. If your client is a claimant, then you proceed to draft out the notice and issue it to the other side.